I stand to also address you on this question of bail. Your Honor, the starting point is that bail is amongst those rights that we will say are ensconced in the Constitution. It is one of the fundamental rights and is integral in that section of the Constitution that we call the Bill of Rights. Your Honor, under Article 19(1) of our Constitution, the Bill of Rights is declared to be an integral part of Kenya's democratic state, and I emphasize, is the framework for social, economic, and cultural policies. And then at Article 20, Your Honor, the same Constitution proclaims that the Bill of Rights applies to all law and binds all state organs and all persons. Every person shall enjoy those rights, Your Honor, and fundamental freedoms in the Bill of Rights to the greatest extent consistent with the nature of the right or fundamental freedom. Your Honor, I don't want to regale you with stories of the Constitution because I know as you sit there, these arguments have been made back and forth. But the reason why I started from there was to emphasize the fact that it is such a right that you cannot trifle with it. It is not something that you play around with. If the state really had compelling reasons, then they would not have done the following. They would not have arrested, because a lot of these accused persons were arrested on Friday. The accused, and you know that this can be verified, but because I'm addressing you on this and they did not give us this in advance, the truth is that they were arrested in a very, very barbaric fashion. In fact, Tarus, I don't know where Tarus is, Dr. Ken Tarus' house was actually upset and the wife placed in the boot of a car for no reason. But the point is this, they can argue about that because those are matters of fact. Yes, thank you. My colleague has reminded me that's a very important thing, and it is to arrest the wife of somebody you are interested in, and she has nothing, she has never worked with Kenya Power Lighting. The only offense she committed was she's the wife of Dr. Ken Tarus. That's the only offense she committed. And in the presence of the children, you go there in the middle of the night after you have arrested a lady as polite as Beatrice Meso. Your Honor, it's important that I emphasize this. A polite lady, a member of our profession called Beatrice Meso, who is actually an advocate of the High Court. You go to a house at 1 a.m. at Muthaiga North, 25 cars. With 25 cars, and each one of them presumed to have had about 5 or 6 men. So 25 times 6, you can imagine how many men those are. And there is no female police officer in sight. With guns. They were armed with guns, needless to say. And there was absolutely no doubt that they were ready to use them. Only that the polite lady that she is, she quickly said, "Where do you want me to go?" And then they go to Tarus' house and cause mayhem. They arrest these guys on Friday. Ask yourself this question, Your Honor. What was this that compelled the Kenya police, who have a solid reputation for investigations, what is this that would impel them to raid somebody's home on Friday night and at 1 a.m.? Yes, please.
I'm reminded by my colleagues. What my learned friend is doing now is giving evidence. And we will be at a serious disadvantage we have no problem with him taking that line if only he complies with the law in terms of procedure. He can offer himself as a witness, that we are ready for, or he chooses to reduce that material into some form that is decipherable and capable of being responded to in a fair manner.
That is less than this.
Kindly stop him from giving evidence.
Issue, and I don't want to, Your Honor, with tremendous respect to the prosecutor, this is such a fundamental issue that is embarrassing that you can raise this sort of objection. So, Your Honor, Friday, you arrest people on Friday. There is no reason, they have not told us why it was necessary to arrest people on Friday in the manner they did. And then you bring them to court on Monday. The only inference you can draw is that somebody just wanted to keep people in custody. How anybody can derive pleasure from keeping another person in custody eludes the defense. And then, Your Honor, to add insult to injury, and Your Honor, it's important for you to note that we came here early in the morning and our colleagues were also here. We were here before you at 9. And our colleagues for the state were also here in the morning. They wait until the court has convened and then throw around things that look like affidavits, which I'm going to address.
With your kind permission, and I have a lot of respect for Mr. Nyakundi.
I also have a respect for you.
Yes. Kindly. Yes. We are actually saying we are ready to respond to the issues or the facts that are being raised. Kindly, just have an affidavit. We will respond to each and every issue.
It is a fact, Your Honor, that we were given these affidavits just a few minutes ago. And the point I'm making there is that anybody who does that, we know how sharp practice is carried out. People wait, and then the last minute, and then you are given things that look like affidavits. But I will respond to this affidavit, especially the one in number 26, and show you how flippant this affidavit and even the other one are. Your Honor, if you look at paragraph 5 of that affidavit, you will see that we are being told that the first accused was a former senior official of Kenya Power and Lighting Company Limited, whereas the second to the 11th accused are senior officers at the Kenya Power and Lighting Company Limited. If it is true that this was sworn by an investigating officer, this investigating officer would have known that the 11th accused actually is not in the service of the Kenya Power and Lighting Limited, having retired more than 1 year ago. So this affidavit, even at the very outset, contains a matter that is not factually correct. In fact, it is perjurious. In other words, when you lie on oath, you commit an offense that is known as perjury. And perhaps we, the defense, when we consult, we could take this matter up. Because if you say a lie in an affidavit, it is a serious issue. And then, Your Honor, if you come to paragraph 6 of that affidavit by our good friend, Walter Oginga Okello, that paragraph tells you, Your Honor, that the fifth accused person is evading the police ever since the DPP gave directions. Even look at that kind of line. Is this a serious effort to oppose bail? Is that compelling? Where is it that is known that the DPP gave any instructions, in order to compel someone to evade arrest? The point in these authorities that we have shown, and the good professor, who is actually a great teacher of the law, he teaches law. The great professor has told you, Your Honor, that these affidavits, and following the decision in Rogers and York, and we had the advantage of participating in that case, myself and Mr. Migosi Ogamba. Following that decision, if you are going to make an objection to bail, and if for it to be compelling, then you must depose such sufficient material in the affidavit that the matter looks compelling. Can it really be compelling to be told that the DPP gave directions as to the arrest and only attended our offices on the 15th of July, even on the basis of what you're reading, Your Honor. First of all, this question of evading police is a red herring. But in this paragraph, Your Honor, you will see that this accused person actually voluntarily presented himself to the police on the 15th of July. What this deponent is telling you, Your Honor, is that he should have done it on Friday so that he can also be in custody like the rest. I think that's bizarre. Paragraph 8 of that affidavit also says that witnesses will be dissuaded. Again, Your Honor, when you look at the authorities, what they tell you is that if there is that likelihood, and for us as the defense, we don't take it lightly. In fact, I can assure you, on behalf of all this team, that as officers of the court, we will not condone our clients interfering with witnesses. We will not. That I can assure this court. And in your long career as a lawyer, Your Honor, because we know you as a distinguished scholar, distinguished jurist, you have actually sat where they are sitting, and you are a senior officer in this court. There has not been serious cases in your experience where people have interfered with witnesses. It is time, Your Honor, that this ghost was put to rest. The ghost that is usually extended to us whenever we appear before you to make this application. So, the point is this, Your Honor, that the witnesses who are dissuaded actually have not been identified at all, nor has it been shown how, by merely being the authorities on that point, by merely being senior officers of Kenya Power and Lighting, that in itself is insufficient to persuade you that they will interfere with witnesses, and the word they are used here is dissuade. Your Honor, ditto, paragraph 11 of the affidavit and so on. What you will see in this affidavit, with tremendous respect, is an attempt to make this affidavit look very big, because it has 23 paragraphs, but in essence, it says nothing. That being the case, Your Honor, and so that we also complete our arguments, there is actually a lot of law in this country. Parliament has been very busy that deals with each of these issues. If it is a question of things like assets and asset recovery, we have a whole regime that allows asset recovery and is usually civil. If there is interference with witnesses, there are specific offenses that have been created by the Penal Code. My point is this, Your Honor, that the totality of the actions by the state will convince you beyond peradventure that this is an institution, especially the DPP's office, is an institution that would like us to trample down upon the fundamental rights. And I want to remind them, Your Honor, that like any state organ, they also are enjoined by law to observe those fundamental rights. We have reached a stage in our practice, Your Honor, where, and it is welcome, just like in other jurisdictions, that if the police want a particular person, unless that person is a ruffian, and these are not ruffians, these are officers who have served this country, I repeat, with distinction in the Kenya Power Lighting. Even a phone call, in parentheses, Your Honor, these objections as expressed in this affidavit are a hollow, and they cannot be compelling as stated in the Constitution. That's all, Your Honor.
Your Honor, I'll make brief submissions owing to the fact that my learned friends have covered quite a bit of latitude. But suffice it to say, Your Honor, that under Article 49(1) of the Constitution, The accused persons before you have a right to bail. Your Honor, I hasten to add that that provision of the Constitution does not make a distinction between a complex or an easy case, as we are told. The Constitution, Your Honor, as you are very much aware, only states that you may deny an accused person bail owing to compelling reasons. And while the Constitution does not define what amounts to compelling reasons, one would imagine, Your Honor, that there would have to be persuasive grounds placed before you in an affidavit which may indicate, Your Honor, amongst others, that either the accused are a flight risk or that they will interfere with witnesses. Your Honor, staying on case number 25, the anti-corruption case 25, and Your Honor, looking at the affidavit of Mr. Walter Okello, the IO, where, Your Honor, he makes statements which I presume are meant to persuade you that there are compelling reasons why you should not grant the accused person's bail. He says, amongst other things, Your Honor, and I'm looking at paragraph number 5, that there is a real danger that the intended witnesses may be dissuaded from appearing and giving evidence against the accused persons. Your Honor, this danger is not defined either in time or in depth. In other words, is the IO asking you to deny the accused persons bail for 1 week, 1 month, or forever? He's not certain himself. So he throws it on your face and says, they are a danger of dissuading witnesses, so don't grant them bail. Your Honor, that cannot be a ground upon which anybody can seriously be seeking to deny an accused person a constitutional right, and one as hallowed as bail, Your Honor. Your Honor, accused number 2, for whom I address you, was given a telephone call in 25. He was given a telephone call on Saturday lunchtime, and while he thought that the IO was going to buy him lunch, they locked him up. So he has ideally been in custody for the last 2 days, treated as though he were a convict. Your Honor, I probably need to pause here and say that there is a culture that is now gaining currency within the prosecution, where suspects are arrested on Friday and kept in custody for 3 days. It is not that they have not written statements. It is not that they have not taken a charge and a caution and inquiry. All that has been done. But they are just kept in custody, I guess, Your Honor, reversing our constitutional order and the constitutional gains we have made since the Constitution 2010. Your Honor, we invite you to show your own condemnation of this action by immediately ordering the release of the accused persons and perhaps writing a page or 2 in your ruling, Your Honor, against this conduct that is now becoming quite prevalent in the administration of criminal law in this country. Your Honor, the right to liberty of any citizen and the right to be presumed innocent until found guilty by a court of law are fundamental principles in the 4th chapter of our Constitution, in realization of which, Your Honor, you should find no difficulty in making a ruling in favor of bail for the accused persons. Your Honor, I pause again to state that the difference between an accused person and a convict must be demonstrated in the manner that this court of itself, Your Honor, considers the application for bail. Keeping the accused persons in custody for one more single day is to pass a message, not just to them, but also to the public, that they are guilty of the charges leveled against them. Your Honor, my senior agenda has stated that the accused person